The morning my ex-husband raised his right hand and swore to tell the truth, the whole truth, and nothing but the truth, I watched my daughter Lily from across the courtroom. She was 9 years old, sitting in the back row with my sister, wearing a navy blue cardigan I'd buttoned myself that morning. She looked small against the wooden bench. She had her backpack on her lap. She held it the way children hold things they've decided are important. I didn't know what was in it. My ex, Daniel Ferreira, stood at the witness stand with the kind of confidence that comes from never having been caught. His attorney, a man named Jeffrey Lund, sat with his legal pad and his expensive watch and his practiced calm. Daniel smoothed the front of his jacket. He looked at the judge. He looked at Jeffrey. He did not look at our daughter. Mr. Ferreira, Jeffrey began, is it true that you have made every required child support payment in the amount of $500 per month for the duration of the agreed upon period? Daniel didn't hesitate. Yes, every single one. I am Nora Scott. And sitting at that table next to my attorney Camille Osei, I did not panic. I did not flinch. I did not react at all. Because 6 months earlier, something had happened that I hadn't fully understood yet. And in the backpack on my daughter's lap, she had been carrying the answer the whole time. The judge was going to hear that lie. And then, after the ruling, Lily was going to hand me an envelope. And everything was going to change. But to understand why that moment in the courtroom hit me the way it did, like something finally clicking into place rather than something falling apart, I need to take you back to where Daniel and I started, and more importantly, where I started. Because the woman sitting at that plaintiff's table had not been built overnight. She had been built in the years that Daniel Ferreira spent assuming she wasn't building anything at all. Let me tell you how we got here. Daniel and I were married for 7 years. We met when I was 26, when I was working in contract administration for a mid-sized logistics company, and he was a commercial real estate agent with a good commission streak and a very attractive certainty about everything. He was the kind of man who made decisions quickly and assumed the world would cooperate. For a while, it did. For a while, I mistook that certainty for strength. We had Lily in the third year of our marriage. She came into the world loud and opinionated, and I loved her so immediately and so completely that everything else rearranged itself around that fact. Daniel loved her too, in his way. His way involved working more and being home less and referring to parenting as something I was so naturally good at, as if that excused him from it. The cracks in our marriage are not the point of this story. What matters is what happened in the 2 years after I filed for divorce. What matters is that Daniel signed a consent agreement stipulating $500 per month in child support, and then proceeded to pay it sporadically, partially, and eventually not at all. What matters is that when I documented this, carefully, consistently, the way I document everything, he told his attorney it was a misunderstanding. Told his mother it was my fault for making everything so adversarial. Told Lily, when she asked why daddy didn't come to her school play, that mom's schedule made it complicated. He lied about small things so often that I think he had stopped recognizing them as lies. They were just the version of events that was more comfortable for him. The first incident I remember clearly, the first one that told me exactly who I was dealing with, was about 6 months after we separated. We were still working out the temporary custody arrangement. I had asked Daniel in writing to confirm that Lily's health insurance coverage would remain continuous during the proceedings. She had been seeing a pediatric occupational therapist named Dr. Rosario Aquino for a sensory processing issue we'd identified when she was 5, and the sessions were not cheap. The coverage through Daniel's plan was something I had specifically protected in our initial agreement. He confirmed it in a text message. Yes, of course, Lily's coverage is fine, don't worry about it. 3 weeks later, I received a statement from Dr. Aquino's office indicating that the last 2 sessions had been denied. Plan not active. When I called Daniel, he told me there had been a billing glitch. He would sort it out. He did sort it out 4 weeks later, after I had paid out of pocket for 2 sessions and filed a formal complaint through our attorneys. But the billing glitch had required him to call the insurance provider, who informed me later, when I called separately to verify, that the policy lapse had been the result of a missed premium payment on his end, not a billing glitch. A missed payment he had chosen not to mention. I paid what I needed to pay. I kept every receipt. I noted the date, the amount, the reason. I started a folder on my laptop that I labeled simply documentation. It grew steadily over the following months. I did not yell at Daniel about the insurance. I did not forward the insurance provider's statement to his mother or post anything online. I called Camille Osei, the family law attorney I had retained through a referral from a colleague, and I told her what had happened. Camille had been practicing family law for 18 years. She had sharp eyes and a very precise way of summarizing situations that I found deeply reassuring. Add it to the file, she said. Don't react, document. So I documented. The second incident that clarified things was a conversation with Daniel's mother, Helene Ferreira, at what was supposed to be a co-parenting exchange at her house the following spring. Helene was a woman who believed strongly in the importance of family and expressed that belief primarily by criticizing the choices of the women who had married into it. She had never been openly hostile to me. She was too composed for that, but she communicated her disappointments through careful, precise observations delivered in a pleasant tone. That afternoon, while Lily was in the backyard with Daniel's younger brother and I was waiting in the kitchen for the handoff, Helene offered me coffee and then, while she was pouring it, mentioned that Daniel had told her things were getting complicated with the financial arrangements. "I hope you're not being unreasonable," she said, setting the mug down in front of me. "He's trying his best." I wrapped my hands around the mug. I looked at her. She had a very specific gesture she used when she was waiting for someone to capitulate, a slight tilt of her head, her eyes a little too patient, her lips pressed in a sympathetic, almost smile. "I'm not being unreasonable," I said. "The payments have been difficult for him. The market has been soft." The market, I knew, had not been particularly soft. I had seen Daniel's car. I had seen the vacation photos on a mutual friend's social media, but I didn't say any of that. What I said was, "I understand." And then I finished the coffee and waited for Lily. That night, I opened my laptop and sent Camille an email summarizing the conversation. Not because it was evidence of anything illegal, but because it told me something important. Daniel's family believed his version of events. They believed him because he had constructed a narrative in which he was a man doing his best in a difficult situation, and I was a woman making that situation more difficult than it needed to be. If you have ever been in a room with someone who is confidently stating something false about you, something you know is false, something you could disprove in 30 seconds, but where disproving it in that moment would only create more conflict, you know what it costs to stay quiet. You know the particular discipline it requires. I had gotten very good at that discipline. Not because I was passive, because I had a plan. Here is what that plan looked like practically. I had spent the first year after our separation doing two things simultaneously. The first was building my professional practice. I had left the logistics company during the marriage to work as an independent contracts consultant, a shift that Daniel had been lukewarm about at the time, but had accepted because my income had remained consistent. After the divorce proceedings began, I had formalized that practice into a registered LLC, brought on 3 long-term clients, and, in the January before the custody hearing, signed a retainer agreement with a regional distribution company that represented the most significant contract of my career to that point. $68,000 annually, renewable. My accountant, a woman named Beverly Cho who had been managing my books since I'd gone independent, had reviewed the agreement and told me it was solid. I had also, in that same January, established a 529 college savings account for Lily. The initial deposit came from a tax refund and a portion of my first payment from the new retainer. The account was registered in my name as custodian. It was not large yet, just under $14,000, but it was growing, and it was mine to manage, and it was not something Daniel knew about. I hadn't hidden it from him out of deception. I hadn't mentioned it because it wasn't his business. Lily's future was something I was building without him, because he had demonstrated, consistently, that his version of providing for her was largely theoretical. The third incident, and this one I think about differently now, because of what Lily told me later, happened on a Tuesday afternoon in September, roughly 8 months before the custody hearing. Lily had come home from school quieter than usual. She was 8 at the time, and she had always been a child who processed things internally before she talked about them, so I didn't push. We made dinner together, which was our routine. She chopped vegetables while I handled the stove, and we talked about small things, her teacher, a book she was reading. After dinner, while I was doing dishes, she came and stood next to me. "Mom," she said, "Daddy told me he sends you money every month." I turned the water off. I dried my hands on the dish towel. I turned to look at her. "He said that?" "He said he always pays you. He said you just forget sometimes." I looked at my daughter's face. She was watching me carefully, the way she did when she was trying to figure out what was true by watching how I reacted. I crouched down so we were at the same level. I said, "Your dad loves you very much, and grown-up money stuff can be confusing." I said it evenly, without adding anything else, because she was 8 years old and she did not need to carry the weight of what I knew. She nodded. She looked like she was still deciding what to believe. That night after she was asleep, I sat at my kitchen table and reviewed my documentation folder for the first time in 3 weeks. 17 months of records, payment dates, amounts received versus amounts owed, deposit confirmations and bank statements showing the gaps, 3 months in a row with nothing. 2 months of partial payments at half the agreed amount. 1 month with a payment that arrived 23 days late and had been for the wrong amount entirely, which Daniel had subsequently claimed was the bank's error. The total unpaid balance as of that September was $11,500. I had a folder on my laptop. I had a very good attorney. I had Beverly Cho reviewing my financial records quarterly to ensure that everything was clean and clearly documented. And I had, as of 3 months prior, formally requested through Camille's office a financial disclosure from Daniel, a formal, court-required accounting of his income and assets during the support period. He had submitted a disclosure that his attorney had signed off on. I had sent it to Beverly. Beverly had spent 2 hours with it and called me to say, in her particular quiet way, that she had some questions about the expense deductions Daniel had claimed. What kind of questions? I had asked. The kind, Beverly said, that I'd like a little more time to look at. I told her to take the time she needed. None of this, not the documentation folder, not the college fund, not Beverly's questions, not Camille's formal disclosure request, had been visible to Daniel or his family. What they saw was a woman managing a modest consulting practice, raising a daughter on a tight budget, pursuing child support through the courts because she couldn't make ends meet without it. That was the story that made sense to them. That was the story that made Daniel's version of events feel plausible. What they didn't see was the retainer agreement in my desk drawer. What they didn't know was that Camille and I had met 6 times in the preceding year, and that our most recent meeting, on a Wednesday morning in late October, had been specifically about timelines. About what we could prove, when we could prove it, and what the hearing was likely to look like. They'll claim the missed payments were temporary, Camille had said, sitting across from me in her office with the disclosure documents spread between us. Hardship, market conditions, intention to pay. And Beverly's findings? Camille tapped the edge of a page with her pen. If Beverly can document what she thinks she's found, that changes the conversation significantly. I nodded. I knew what Beverly thought she'd found. We hadn't spoken about it explicitly. Beverly was careful with language, but she had used the word pattern twice in our last conversation. The kind of pattern, she'd said, that tended to become visible when you looked at business expense reporting alongside personal spending records over an extended period. I left Camille's office that morning and drove to pick Lily up from school. She ran to the car the way she always did, backpack swinging, telling me something about a project before she'd even gotten her seat belt on. I listened. I asked the right questions. I made dinner. I helped with homework. I did the bedtime routine. And then I sat at my kitchen table with my laptop open and a cup of tea that went cold before I touched it. And I looked at what we had, and I thought about the hearing date, and I thought about my daughter standing next to me in the school pickup line, and I thought about the look on her face the night she told me what her father had said. The hearing was scheduled for the following spring. We had approximately 5 months. I had spent 16 months building something that Daniel didn't know existed. Evidence he hadn't thought to hide because he hadn't believed I'd look. A professional situation he'd underestimated because he'd stopped paying attention. A legal partnership with Camille that had been running quietly and precisely since the month after we separated. None of it felt like enough. It never feels like enough when you're still in the middle of it. But I had one advantage that I couldn't have planned for and didn't fully understand yet. My daughter was paying attention in ways I hadn't asked her to. She was watching her father the way children watch people they love and are confused by. She was filing things away in a mind that was far sharper than anyone around her had recognized. And she had apparently been carrying something in her backpack for 6 months. I didn't know that yet. In October, I only knew what I had built. I didn't know what she had built alongside me quietly, without telling anyone. The first close call came in November, at what was supposed to be a straightforward pickup exchange at Daniel's apartment. Lily had a school project due that required some materials she'd left at his place, and I had texted him to confirm I could stop by briefly while he was there. He said yes. When I arrived, his mother was visiting. Helen was sitting at the kitchen table with a cup of tea, and the look she gave me when I came through the door was the particular look she reserved for situations she felt were beneath her dignity to address directly. Daniel was in the back hallway. I could hear him on the phone. Helen set her cup down. Lily told me you've been doing quite well, she said, and the phrasing of it, quite well, had the texture of a question disguised as a compliment. We're doing fine, I said. That's good. Daniel worries, he worries that the financial pressure is affecting her. Lily is doing beautifully. Her therapist says she's made significant progress this year. Helen's hand moved to the charm bracelet she always wore when she was about to say something she'd prepared. It must be expensive, she said. The therapy? It is. I do hope the consulting work is keeping up, Daniel mentioned you'd had some slower months. This was the moment I felt most clearly. Daniel had told his mother about my work. He had characterized it, slower months, in a way that positioned me as financially precarious, which served his narrative about the financial strain of support payments. He had told her enough to make me look unstable, not enough to make himself look dishonest. November was actually my strongest month, I said, not elaborating, not explaining, just saying the true thing and leaving it there. Helene picked up her tea again. She tilted her head the way she did. Well, that's a relief. Daniel came in from the hallway. He was still holding his phone, and when he saw the expression on his mother's face and then looked at me, something moved through his features quickly, a reassessment of what had been said in his absence. His signature tell was that slight forward lean, like he was about to take a step and then thought better of it. Nora, he said, the project materials are in Lily's room. Thank you. I moved past him toward the hallway. I got the materials. I found Lily, who was in her room drawing something elaborate in a sketchbook. She looked up at me and smiled. I kissed the top of her head. I told her I'd see her on Friday. In the car, I called Camille's office and left a message asking her to note in our file that Daniel had discussed my financial situation with family members in a characterizing way. It wasn't evidence of anything, but it was a pattern I wanted on record. Camille called back 40 minutes later. Before I could summarize the exchange, she said, Beverly finished her review. I pulled into a parking lot. What did she find? She'd like to walk us through it in person. But Nora, Camille paused, and in 18 months of working with her, I had learned that her pauses meant the next sentence was significant. She found the pattern. Beverly met us the following week at Camille's office on a Thursday morning. She brought a printed summary that she walked us through, with the same calm precision she brought to everything. What she had found, examining the financial disclosure Daniel had submitted alongside the records she had independently sourced through the formal disclosure process, was a consistent practice of categorizing personal expenses as business deductions. The expenses included, among other things, 3 months of what appeared to be personal travel costs. 2 of those months corresponded directly to months in which Daniel had submitted no child support payment. It was not, Beverly said carefully, something she could testify to without additional verification. But it was the kind of thing that, presented alongside the payment records I had been keeping for 16 months, told a coherent story. How coherent? I asked. Beverly looked at Camille. Camille looked at her legal pad. Coherent enough, Camille said, that I want to change our approach to the hearing. I sat with that for a moment. Outside the window of Camille's office, it was raining. The kind of thin November rain that doesn't commit to anything. What does changing the approach look like? It looks like we don't simply argue the missed payments. We argue the pattern. We show that the payments were not missed because of financial hardship. We show that they were missed in months when funds were demonstrably available for other purposes. I nodded slowly. And Daniel doesn't know we have Beverly's findings. His attorney received the disclosure request response, Camille said. He doesn't know what we did with it. I looked at the rain. The second close call happened 3 weeks later, at Lily's school winter performance. It was one of those events where both parents were present, and the unspoken understanding was that we would be cordial and separate and focused on the child on stage. Daniel sat with his brother Mateo on the other side of the auditorium. I sat with my sister Claudia and our parents, who had driven up from 2 hours away for the occasion. During the intermission, Daniel crossed the auditorium to where we were standing. He had a particular walk when he was performing Confidence, shoulders back, chin up, a slight delay before he smiled that was meant to look like composure, but that I recognized, after 7 years, as him deciding what tone to use. He greeted my parents warmly. He greeted Claudia. He turned to me and said, in a voice that was low enough to be private and pleasant enough to be deniable, I wanted you to know the attorney situation should resolve soon. Jeffrey is optimistic about the hearing. I'm sure he is, I said. I just want this to go smoothly, for Lily's sake. So do I. He held my gaze for a moment. He was looking for something in my face, some sign of how worried I was, how much of an advantage he thought he had. I gave him nothing. Not coldness, not warmth. Just the steady, neutral surface of a woman who had already made her preparations and was waiting. He nodded once. Good, good, that's all I wanted. He went back across the auditorium. My mother, who had watched this exchange from 2 feet away, touched my arm. Are you all right? I'm fine. He seemed, Mom, I found her eyes. I'm fine. She nodded, though she didn't look completely reassured. My mother was a woman who believed very much in the importance of knowing how a situation was likely to go, and she had not yet been given reason to believe that my situation was likely to go well. I had not told her about Camille's strategy. I had not told her about Beverly's findings. I had told her that I had a good attorney and that I was handling it. Lily appeared backstage afterward in her costume, flushed with the particular energy of a child who has just performed in public for the first time. She ran to me first. She grabbed my hand and pulled me toward the backstage area, talking rapidly about a moment in the second number when someone had dropped their prop and she'd had to step around it. I listened to every word. Daniel came backstage a few minutes later, and Lily grabbed his hand too, and for a moment we were both just her parents, listening to her tell the story of the prop and the step around. For a moment it was just that. He left first. Lily watched him go. Then she looked up at me with an expression I couldn't quite read, something careful, something private. She had been doing that more recently, looking at me as if she was weighing whether to say something. She didn't say anything that night. She tucked her hand into mine and walked with me toward the car. 4 months before the hearing, I met with Camille one final time to finalize our approach. We sat in her office for 3 hours. We went through every payment record, every date, every confirmation and gap. We reviewed Beverly's summary. We talked about what to expect from Jeffrey's strategy and how we would respond. At the end of the meeting, Camille put down her pen and looked at me directly. Nora, how are you doing? I'm ready. That's not what I asked. I thought about it for a real moment. I'm tired of waiting, I said. I've been building this for a long time and I'm tired of waiting to use it. She nodded. 4 months. 4 months, I agreed. I drove home. I picked Lily up from school. I made dinner, helped with homework, and somewhere in those ordinary hours, my daughter was sitting in her room with a pen and a piece of paper, writing something she had decided she needed me to have. Writing something she had been keeping for 6 months, watching carefully, understanding more than I had asked her to understand, being a witness in the quiet way that children become witnesses when adults forget they are watching. I didn't know that yet. I only knew what I had built. But the hearing date was getting closer. And everything I had assembled, the documentation, the disclosure findings, the retainer, the college fund growing quietly in the background, Camille's 18 years of experience, Beverly's pattern, all of it was going to meet Daniel's lie in a courtroom in front of a judge on a morning in spring. And my daughter was going to be sitting in the back row. She was going to be holding her backpack in her lap. And the envelope inside it, the one she had been carrying for 6 months without saying a word, was going to be the thing that none of us had planned for. Not Daniel, not Jeffrey Lund, not even me. The timing, as it turned out, could not have been more perfect. The hearing was scheduled for the 14th of March. I know the date precisely because I had been counting backward from it for 4 months. The way you count backward from a deadline, when the work is already done, and all that remains is the moment of presentation. The morning of the hearing, I woke at 5:15. I made coffee. I dressed carefully, a charcoal blazer I had bought specifically for this, not because I was performing anything, but because I wanted to feel like myself in a room that was going to try to make me feel like less than that. I drove to my mother's house to drop Lily off because my mother had agreed to bring her to the courthouse later, after the morning session, if the schedule allowed. Lily was already awake when I arrived. She was sitting at the kitchen table in her pajamas with a glass of orange juice, and when I came through the door, she looked at me with that careful, assessing expression she'd been wearing more and more frequently in recent months. "You look nice, Mom," she said. "Thank you, baby. Is today the judge day?" "It is." She considered this for a moment, turning the juice glass slowly in her hands. "Will Daddy be there?" "He will." Another moment. "Okay," she said, and then she went back to her juice. I kissed the top of her head. I told my mother I'd call when I had news. My mother held my arm a beat longer than she needed to and said, very quietly, "You've got this, Nora." It was the most direct thing she'd said about the hearing in 4 months, and it landed somewhere soft. I drove to the courthouse. Camille was already in the hallway outside the family courtroom when I arrived, reviewing something on her tablet with the focused stillness of a person who has done this so many times that the adrenaline has been replaced with something more useful. She looked up when she saw me, nodded once, and said, "Ready?" "Ready." Beverly's summary is tabbed and organized. I have the payment records going back to month 1. Jeffrey is going to lead with hardship and intention. She paused. Let him. Disclosure findings make the hardship argument very expensive for them. We went in. Daniel was already seated at the opposite table with Jeffrey Lund. He wore a gray suit I didn't recognize, new, I thought, probably recent. He looked confident in the way people look confident when they believe the narrative they've constructed is the only one in the room. He didn't look at me when I sat down. His tells were specific, that forward lean, that slight recalibration before he decided on a tone. Today he was sitting back. He thought he had nothing to worry about. Jeffrey made his opening remarks. He was precise and fluid, a good attorney doing what good attorneys do, which is make one version of reality sound like the only version of reality. He characterized the missed payments as a temporary disruption during a period of market volatility in commercial real estate. He characterized Daniel as a committed father who had every intention of making the support obligations whole. He characterized me, with careful oblique language, as a party who had chosen litigation over resolution. I kept my face composed. Camille kept her pen moving. The judge was a woman named the Honorable Ruth Carmona, mid-50s, with the particular economy of expression that comes from presiding over family court for many years. She listened to Jeffrey's opening without visible reaction. When he finished, she gave Camille the floor. Camille's opening was 4 minutes long. She presented the payment record. She noted the total unpaid balance, $11,500, across the period in question. She noted the dates of the unpaid months. She noted that a formal financial disclosure had been requested and received. She said that we had questions about the disclosure that we intended to address during testimony. She sat down. That was when Daniel raised his right hand. And that was when he swore to tell the truth, the whole truth, and nothing but the truth. And that was when Jeffrey asked him if he had made every required payment. And Daniel said, without hesitation, yes, every single one. I didn't react. I looked at my hands flat on the table in front of me. I thought about Beverly's printed summary in the folder to Camille's left. I thought about 16 months of documentation. I thought about Lily at my mother's kitchen table, turning a juice glass slowly in her hands. I thought, he has no idea what is in this room with him right now. Camille cross-examined Daniel for 22 minutes. She walked him through the payment record systematically, month by month. He stuck to his narrative, processing delays, banking errors, an accounting issue that had since been corrected. His voice was steady. Jeffrey objected 3 times, Judge Carmona sustained 1 and overruled 2. When Camille reached the 3 months that Beverly had flagged, the months with no payment and the months that corresponded to documented personal expenditures in the disclosure, she set the payment record down and picked up Beverly's summary. Mr. Ferreira, you testified that the missed payment in July of the prior year was the result of a banking error. Is that correct? That's correct. Camille tilted her head. Are you aware that in the same month you report a banking error prevented your support payment from processing, your financial disclosure includes a travel expense of $3,200 charged to your business account? Jeffrey was on his feet. Objection, relevance. Goes to financial capacity, Your Honor, Camille said calmly. Judge Carmona, overruled, the witness will answer. Daniel's forward lean came then, the tell, the recalibration. That was a business trip. A business trip. Camille made a brief note. And the following month, August, when there was again no support payment received, was there also a banking error in August? A pause, 2 seconds too long. There may have been a delay in processing. A delay. Camille picked up the next page. Mr. Ferreira, your disclosure for August includes a personal expense categorized as a business entertainment deduction in the amount of $1,800. Can you describe the nature of that entertainment expense? Jeffrey objected again. Judge Carmona looked at him with the patience of someone who had been in this room 1,000 times. Overruled. Answer the question, Mr. Ferreira. Daniel pulled his phone from his jacket pocket, looked at it, put it back. I'd need to review my records. Of course. Camille turned a page. We'll come back to it. She didn't come back to it. She didn't need to. The question had done its work. The pattern was now in the record. After Daniel's testimony, Camille called Beverly to the stand as a financial expert witness. Beverly Cho was not a dramatic person. She was a methodical person, which, in a courtroom setting, is considerably more useful. She walked Judge Carmona through the findings in her summary with the same quiet precision she used in our office meetings. She did not characterize. She did not accuse. She presented figures, dates, and the internal inconsistencies between the disclosed business expenses and the payment record across the relevant period. Jeffrey's cross-examination of Beverly was brisk. He questioned her methodology. Beverly answered each question fully and without defensiveness. When Jeffrey suggested that the expense correlations were coincidental, Beverly said, the pattern I've described appears across 6 discrete months. Coincidence is possible. Consistent pattern is a different category. Jeffrey sat down. Judge Carmona reviewed the materials for 8 minutes. 8 minutes of complete quiet in that room, with Daniel sitting at his table with his hands folded, and Jeffrey writing something I couldn't see, and Camille sitting beside me with her pen down. She'd put it down when Beverly stepped off the stand, which I noticed, and which told me something. Then Judge Carmona looked up. She did not rule immediately. She said she wanted to review additional documentation and scheduled a follow-up session for 3 weeks out. She said she had concerns about the completeness of the financial disclosure as presented. She said she was entering a temporary order requiring Daniel to provide supplementary financial records going back 24 months. She dismissed the session. Daniel stood up from his table. For the first time since we'd entered that room, he looked at me. His expression wasn't angry. It was something more complicated than that. The particular look of a person who has just realized the room they thought they were standing in is a different shape than they believed. I held his gaze for exactly long enough. Then I picked up my folder and turned to Camille. Good, she said, and that was all. It was 2:47 in the afternoon. I stepped into the courthouse hallway and called my mother. How did it go? She asked immediately. It went well. The judge is requesting more documentation from his side. There's a follow-up session in 3 weeks. A long exhale on her end. Okay, that's good, right? It's very good. Is Lily there? She's right here. She's been asking about you all afternoon. Lily came on the phone. Mom, did the judge listen? She listened very carefully. Good. A pause. Mom. Can I give you something when you get here? I made something. I've been keeping it. I stopped walking. What did you make, baby? It's a letter. I wrote it a long time ago. I've been keeping it in my backpack because I didn't know when was the right time. Another pause, very brief. I think it's the right time now. My hand tightened around the phone. I stood in the courthouse hallway and kept my voice very steady. I'm on my way. She had been keeping it for 6 months. A child's sense of timing, operating on its own logic, landing exactly where it needed to land. I drove to my mother's house. I sat at the kitchen table. Lily came and stood beside me, backpack still on, and she reached inside and pulled out an envelope that had been folded carefully, twice, like she'd been protecting it. She set it in front of me. On the outside, in her handwriting, 9 years old, round letters, a little uneven, she had written, "For Mom, private." I wrote it, she said, because Daddy told me a lie. And I wanted to write down the truth so I wouldn't forget it. I opened the envelope carefully. Inside were two things. The first was a letter, 2 pages in her handwriting, which I will tell you about. The second was something I had not expected. A folded collection of screenshots she had taken on an old tablet she used for reading apps, printed out at school on the one day a week she stayed for homework help in the library. She had asked her teacher, apparently, if she could use the printer for a school project. Her teacher had said yes. The screenshots were text message conversations between Daniel and his brother Mateo. Lily had seen them on Daniel's phone one afternoon when he'd handed it to her to show her a video and then stepped out of the room. She had photographed them with the tablet camera. She had printed them. She had carried them in her backpack for 6 months because she was 9 years old and she understood that what she had seen was important, even if she didn't have words for why. The messages were a conversation between Daniel and Mateo from the previous September, the same September that Lily had come home quiet and told me that her father said he always paid me. In the messages, Daniel told Mateo that he'd been routing money through the business account to show lower personal income ahead of the hearing, that he'd been doing it for almost a year, and that Jeffrey had told him the financial disclosure didn't need to include every business account transaction as long as the characterization held up. That last part, as long as the characterization held up, was the phrase that stopped me. I went through the pages once, then I went through them again. Lily was sitting across from me at the table, watching me with those careful eyes. You kept these, I said. I saw them by accident, she said quickly, like she needed me to know that. I wasn't trying to look. He showed me a video and then he went to answer the door and I saw the messages come in and she stopped. I didn't know if it was okay. I asked my teacher if keeping evidence was good or bad and she said it depends on what you do with it. I looked at my daughter for a long moment. She had been sitting with this, with the weight of it, with the not knowing when to give it to me for 6 months. She had made a decision, entirely on her own, that today was the right time. Lily, my voice came out quieter than I intended. This was very brave. She considered this seriously. I just didn't want you to not know. I called Camille from my mother's back porch 20 minutes later. I told her what Lily had brought me. There was a long pause on Camille's end, not her usual pause, which was measured, but something longer. Read me the exact language from the messages, she said. Slowly, I read her the key portions. Another pause, then, Nora, this is potential evidence of deliberate misrepresentation to the court. That is a different category of problem for Daniel than what we established today. I know. We need to get those originals, the screenshots, authenticated and submitted before the follow-up session. Beverly is going to want to see the routing information referenced in the messages alongside what she already has. What does this mean for the case? Camille's voice shifted into the register she used when she was being precise. It means that what Daniel told the judge today under oath is now contradicted by documented evidence of his own statements to a third party. That is not a banking error. That is not a characterization issue. That is perjury, Nora. I stood on my mother's back porch in the March cold and let that word settle. What happens now? We file an emergency motion to supplement our evidence record before the follow-up session. We alert the court to the existence of new material evidence, and we let Judge Carmona decide what to do with a witness who swore to tell the truth and did not. The follow-up session was scheduled for April 4th. Camille filed the supplementary motion within 48 hours. Beverly reviewed the screenshots alongside the routing patterns she'd already identified and produced an addendum to her original summary that was, in her words, materially significant. Jeffrey Lund requested a continuance. Judge Carmona denied it. On the morning of April 4th, Daniel came into that courtroom looking different. The new gray suit was the same, but the way he wore it had changed. He sat forward this time, both elbows on the table, which was the opposite of his posture 3 weeks earlier. His forward lean was constant now, not the recalibration before he decided on a tone, but something more pressured. Jeffrey was writing steadily on his legal pad. Neither of them spoke. Camille presented the supplementary evidence. She walked Judge Carmona through the screenshots. She walked her through Beverly's addendum, which connected the routing patterns Daniel had described in his messages to Mateo with the specific expense entries in the financial disclosure. She presented it the way Beverly had taught me to present documentation, not dramatically, but systematically, until the shape of it was unmistakable. Judge Carmona reviewed the materials. She asked Jeffrey 3 questions, each of which he answered carefully, without looking at Daniel. Daniel's attorney asked to confer with his client. The judge allowed it. Jeffrey leaned toward Daniel and spoke in a voice too low to hear from our table. I watched Daniel listen. I watched something happen in his posture, a slow deflation, starting at the shoulders, moving through his whole frame. He said something back to Jeffrey. Jeffrey's hand went flat on the table. Daniel looked away. When the session resumed, Jeffrey addressed the court. Your Honor, we would like to request the opportunity to discuss a revised settlement structure. Judge Carmona looked at him over the top of her glasses. Her expression was the particular expression of someone who has been in this courtroom for a very long time and has seen this specific moment before. Mr. Lund, I'm going to be direct with you. The evidence before me suggests that your client made statements under oath in the prior session that are materially inconsistent with documented communications. I am referring this matter to the district attorney's office for review of potential perjury charges. That referral is separate from what this court decides today about the support order. Jeffrey's pen stopped moving. Daniel looked at the judge for the first time since the session had started. Then he looked down at the table. His hand came up and pressed flat against his chest, briefly, like he was checking something. Then it came back down. Judge Carmona reopened the case. She set aside Daniel's testimony from the prior session entirely. She ordered a full accounting of Daniel's financial activity for the preceding 24 months, to be conducted by a court-appointed financial examiner working alongside Beverly's existing documentation. She entered a modified support order immediately. Full arrears of $11,500 to be paid within 60 days, plus a restructured monthly payment reflecting Daniel's actual income as established by the examination, which was substantially higher than what the original consent agreement had been based on. She also, before closing the session, looked directly at Daniel and said something that I have thought about many times since. She said, Mr. Ferreira, this court's first obligation is to the welfare of your child. What that child needed from you, you chose not to provide. I will not allow documentation of your financial circumstances to be shaped by what is convenient for this proceeding. Jeffrey thanked the court and closed his folder. His expression was the expression of a man who has done his job and cannot be held responsible for what his client did. Daniel did not look at me when we left the courtroom. He stood in the hallway with Jeffrey for a long time. I walked past them without stopping. Camille and I sat in a coffee shop 2 blocks from the courthouse. She had her hands wrapped around a mug and she looked, for the first time in 18 months, like someone who had set something down. Beverly's going to finalize the examiner handoff documentation this week, she said. The 60-day payment window starts today. And the DA referral? That's out of our hands. It's the court's decision now, not ours. What I can tell you is that the evidence as submitted is clear. She paused. Lily's screenshots, authenticated through the tablet's metadata, are part of the official court record. I thought about Lily making that decision alone. A 9-year-old deciding that today was the right time, folding those pages carefully, carrying them in her backpack for 6 months without saying anything. She knew what she had, I said. Camille tilted her head slightly. She did, she's a very perceptive child. She got it from spending too much time around adults who thought she wasn't listening. Camille almost smiled. That is frequently how it works. I finished my coffee. I went back to my mother's house. Lily was at the kitchen table doing homework, her backpack on the floor beside her chair, lighter now than it had been for half a year. When she heard me come in, she looked up. Mom, what happened? I sat down across from her. The judge reopened the case. She processed this. Is that good? It's very good. She looked at her homework, then back at me. Did my letter help? I reached across the table and covered her hand with mine. It helped more than I can explain right now. She nodded in that serious way she had. Good, she said. And then she went back to her homework, because she was 9, and she had been carrying something heavy for a long time, and now she could put it down. In the weeks that followed, the court-appointed financial examiner completed his review. The findings confirmed what Beverly had identified, a pattern of expense categorization over 14 months that had materially misrepresented Daniel's available income during the support period. The total financial obligation recalculated under the modified order, including arrears and the structured prospective payment, came to $31,000 over the 24 months of examination. Daniel paid the 60-day arrears through his attorney's escrow account, which told me that he had the money, had always had the money, and had chosen, specifically and deliberately, not to send $500 a month to his daughter. The district attorney's office reviewed the perjury referral. Charges were ultimately not filed. The DA's determination was that the messages, while inconsistent with Daniel's testimony, presented evidentiary complexity that made prosecution difficult without additional corroboration. I did not agree with that assessment, but I understood it, and I had Camille's assurance that it had been considered seriously, and the court record reflected what Daniel had done regardless of whether it resulted in criminal charges. What the court record also reflected was that Judge Carmona's modified support order was binding, enforceable, and included an automatic wage garnishment provision if Daniel missed a single payment going forward. He has not missed one since. Jeffrey Lund withdrew from Daniel's representation 2 months after the hearing. I don't know why, and I didn't ask. Daniel retained a different attorney for what became a protracted renegotiation of the custody schedule, a renegotiation that resulted, ultimately, in a structured arrangement that gave Lily stability and gave Daniel accountability. He sees her every other weekend and on designated holidays. He calls when he says he will now. I think the courtroom clarified something for him about what happens when he doesn't. Helene Ferreira called me once, about 6 weeks after the April session. She asked if we could speak. I said yes. She was quiet for a long time and then said that she hadn't known the extent of it, the pattern of it, and that she was sorry for what she'd said about me making things adversarial. I listened. I said I appreciated her calling. I did not say that it changed anything about the preceding 2 years because it didn't, but I didn't need it to. She had a signature tell, that head tilt, those patient eyes. Even on the phone, I could sense her waiting for me to make it easier for her. I didn't make it easier. I just said what was true, that what mattered now was Lily, and that we could both agree on that. She agreed. We ended the call. Lily is doing beautifully. Her sessions with Dr. Aquino continue, covered by a plan I arranged independently after the hearing, the coverage through Daniel's employer having become something I no longer wanted to depend on. The college fund has grown. Beverly reviews it quarterly. At the rate it's growing, it will be meaningful by the time Lily needs it. What I keep coming back to is not the courtroom, not the screenshots, not the look on Daniel's face when Jeffrey stopped writing. What I keep coming back to is a 9-year-old at a kitchen table, deciding on her own that today was the right time. Not because I asked her. Not because any adult guided her. Because she had been paying attention, and she trusted that telling the truth was worth the weight of carrying it. She asked me once, a few months after everything settled, if Daddy was in trouble. I told her the truth, which was that some things he had done were being looked at very carefully by people whose job it was to make sure things were fair. She considered this for a moment and then said, "I'm not glad he's in trouble. I just didn't want you to not know." I told her that was exactly right. That was exactly the right way to feel. I'm not a person who uses words like closure easily. I don't think situations like this close. Exactly, I think they settle, the way water settles, into a level that you can navigate. What I know now that I didn't know 18 months ago is the particular quality of quiet that comes after you've stopped carrying something. The house feels different. My mornings feel different. I wake up and I make coffee and I pick up Lily and I drive to client meetings and I come home, and none of it is overshadowed by the thing I was waiting to resolve. That's not nothing. That's actually everything. So tell me, did Lily do the right thing? Or should a 9-year-old never have had to make that decision at all? I want to know what you think.